Breach of confidence. In the previous videos, we have considered the different forms of intellectual property protection. We've seen that copyright law protects a variety of creative expressions, including texts, images, and video recordings. We've seen that trademark law protects brand names and logos, and we've seen that the law of patents protects innovative and inventive technologies. In this section, we will consider an alternative way to protect valuable information or ideas from being used or exploited by others, and that is by simply keeping it a secret. Now, this is the way many famous companies keep valuable information confidential. They simply keep it a secret. The recipe for Coca-Cola, for example, is not patented. If it was patented, it would have become publicly known many years ago when the patent expired. Instead, Coca-Cola simply keeps the recipe a secret. Now, if information does need to be shared that is supposed to be kept secret, the way in which one can prevent others from disclosing that secret information is by using the tort of breach of confidence. The breach of confidence is a tort that is committed when one person uses information disclosed to them on a confidential basis without the consent of the owner of the information. So if the owner of a business needs to disclose that secret information or secret idea to an employee or to someone else with whom they are working, then if that employee or other person nevertheless discloses that secret information to others, they can be sued under the tort of breach of confidence. For example, in NP Generations and Fenley from 2001, while employed by NP Generations, Fenley compiled an address book containing the contact details of NP Generations customers. After her employment was terminated, Fenley refused to hand over the address book to NP Generations. The court ordered that she hand over the address book. The contact details were confidential information, and her failure to return the book was breach of confidence. To establish that the tort of breach of confidence has been committed, the following requirements must be satisfied. First of all, the information has to be of a confidential nature. Trivial information and public knowledge is not protected by this tort. Secondly, the information must have been given in circumstances where the obligation of confidence was explicitly made known and accepted or was implied from the context. In other words, at the time that the secret information or idea was passed on to the other person, it must have been made obvious to the other person that it was in fact secret or confidential information. And finally, there has to be an unauthorized use or threatened use of the information by the person accused of breaching the confidence. If all three requirements are made out, then the tort has been committed. The second requirement is that it must have been made clear to the other person that the information was secret or confidential, and one of the most common ways to do this is to actually ask that other person to sign a confidentiality agreement. This removes all uncertainty and ensures that all the parties are aware of their obligation of confidence. It also brings contract law into play. If a person has signed a confidentiality agreement undertaking not to disclose certain secret or confidential information, and they nevertheless do so, they can be sued for breach of contract.